consideration when you come to exercise any discretion under sub 1. But
So,
the primary submission.
Yeah, so just picking up on the debate the bench had with Mr. Four on this question, is your submission the same as Mr. Four's or different?
No, it's the same.
It's the same, yeah.
It's the same. And this plainly is, in substance, a second go, an appeal, running exactly the same points as Lord Justice Lewison considered, said he had reflected on, referred to all the submissions in respect of in his second decision and rejected. And the balance of the interests of finality, we suggest, have been struck by the rule quite clearly to prohibit second applications on materially the same grounds. My Lord, we do not suggest that there was in any way an error on my Lord's part to adjourn this matter into court. If this case were to achieve clarification that is what 52.30 sub 7 means and how it is to be interpreted in respect of backdoor appeals like this one, then the case will have achieved a public benefit. Moving on, and I suppose assuming against me that you don't accept that, in respect of ordinary, if I can call it like that, second applications which are on materially or essentially the same basis as the first one. So I'm distinguishing from situations where there's some fraud that's revealed far into the future, which was no part of the initial considerations. As I said in my skeleton, the circumstances need to be overwhelmingly egregious before the court should consider intervening. If I just add a bit of nuance to that submission, as far as underlying fundamental legal error is concerned, the claimant, the applicant, must be made to confront and overcome not just why it is she says that the refusal of permission was shockingly bad or fundamentally flawed, but why the first application to reopen that was refused in a way that meets the same standard. Otherwise, it's effectively to treat the first application as a matter of irrelevance, and with respect, it can't possibly be so. But can I root that submission in what 5230 sub 1 requires? Because, without needing to turn it up, I hope, the test is not, has something shockingly bad gone wrong? If it has, we reopen. The test obviously assumes as a precondition that something shockingly bad has gone wrong, but then it introduces a balance for the court on a discretionary basis with the other interests of justice. And the reason that the egregiousness must infect to a high degree not just the first decision but the second decision is that there's an additional consideration, namely the considerations of finality, which are all the stronger for the first application to reopen having been considered and dismissed. I think that the court in Lowell, paragraph 65, which I think we've been to once or twice today, and it's in my skeleton for ease of reference, frames the question as whether what's gone wrong, what's corrupted the process, is bad enough to override the pressing claim of finality. And my submission is that the pressing claim of finality is all the more pressing where matters have already been considered and looked at. Otherwise, one simply encourages applicants to keep going until they find a Lord or Lady Justice who's prepared to share their opinion.
So to use again, I'm sorry if it's a cliche, but to use an expression we often hear used, the sheet of paper is not blank when we come to application number 2, or 3 or 4 for that matter.
But the hurdle must be higher.
Yeah.
Because the process that 5230 envisaged has already been engaged in, and the applicant needs to explain why that is not enough. And that leads on to another consideration which is clearly relevant here, which is the question of prejudice to third parties. We obviously have well in mind the need for finality in respect of planning, decision making, because parties other than the parties to litigation may derive rights from decisions being challenged and so on. But in this case, we have, and I don't think it's disputed because I didn't hear any dispute on the facts this morning, we have the clearest evidence of potential prejudice on my client's part. Because I trust the court will have looked, it wasn't very long, at Mr. Parkins' witness statement, which sought only to identify steps that have been taken on site.
Spent over 2 million, done the basic landscaping, all of the infrastructure and some of the services, as I understand it, plus 13 new homes and a number of others that are about to be completed.
That's right. Significant works on site. Yeah. And I've only drawn to the court's attention through Mr. Parkins' witness statement, as I say, the steps that were taken after Lord Justice Lewison's decision, and they were taken because of the apparent finality which that decision was thought to bring to these proceedings. And I don't think there's any dispute on the facts.
No. I don't believe, I've not discerned any dispute on the facts. And you would draw a distinction, would you, between the situation in which a developer gets planning permission for say a housing development and proceeds, as it were, in the knowledge of a claim for judicial review of the LPA's decision, on the one hand, clearly taking a risk. You know, there might be a compelling commercial reason for doing it in certain circumstances. By contrast with the situation in which one has got through the process all the way through to permission to appeal being refused, the first instance judgment, and then a 5230 application refused, and Mr. Parkins' facts are from 5th of March, construction works.
Which was the date of Lord Justice Lewison's refusal to reopen.
Yeah, so it was only at that stage that the works began.
The works had, he does say that,
yeah.
For completeness, the works had commenced earlier, but I haven't asked him to put before the court any evidence of works before Lord Justice Lewison's refusal.
No.
So there'd been some work, and he said there were various pauses or reductions in activity, but then 5th of March 2020 was more, as it were, more of a green light.
And that which he has particularised is all work that's taken place since 5th of March. And I accept what my Lord Justice Lindblom puts to me. If I've made these sorts of points to the judge and advanced a discretion argument, please don't quash this.
That might have got short shrift.
I'm sure it would have, and I made no such argument. That's why the evidence is focused specifically on the period since Lord Justice Lewison's second decision, the refusal of the first reopening. Because at that point, in my submission, my clients are entitled to regard the line as having been drawn.
Yeah.
And if the claimant wishes nonetheless to pursue an application, it's plainly incumbent on her to ensure that anything is expedited and heard by this court and determined within days. We're told she lives near the site and is a member of an action group. It's inconceivable. I'm sure the court can satisfactorily infer that she and those of like mind were aware of the works that were going on. Because that wasn't done, here we are in a circumstance where much of the last 7 months we have been working on site in the apparent belief that there were final decisions made in respect of these matters. And that is clearly all relevant to the discretionary exercise under Sub-Rule 1.
Thank you.
My lords, my lady, nothing more on the test. I think that Lord Justice Coulson distilled Mr. Hond's submission accurately, I may suggest, to being that partly Lord Justice Lewison was wrong and partly insufficient reasons for reasons were given. I would submit that on both counts that's not good enough. It's perfectly clear from Goring that whether the judge is right or wrong is not the test. And so far as the reasons issue is concerned, as Mr. Furr has clearly demonstrated, that the reservet standard is no different from the domestic reasons standard. And you will, of course, be well aware of what the expectations are to confront the key issues. It's not made any easier to do that where the grounds of appeal don't follow a logical route, which is undoubtedly the case in the Hoplands case. The ground of appeal 1, the alleged partial HRA, it is, if one's logically going to set out what the issues in the case are, the last point one comes to.
Which no doubt explains why Lord Justice Lewison dealt with the grounds in the order in which he did.
Exactly, and I don't need to turn it up, but at the first reopening stage, my submissions, not knowing that the papers were going to go back to Lord Justice Lewison, focused on explaining how the order of the grounds of appeal was not necessarily followed, but a more logical approach was followed. And that logical approach was to start with grounds 3 and 4, because as the claimant accepted, see her reply in the High Court, Call Bundle E247. I don't need you to turn it up now, but for your reference, if she could get over the discretion point in respect of the outline planning permission stage, that was the end of the case. Yeah. No issues about remedial HRAs and their permissibility would arise, and self-evidently no questions about the sufficiency or cogency of the HRA would arise. And there seems, with respect, to have been a conflation in the minds of those drafting the various grounds of appeal and later submissions on the other side, which Mr. Furr has referred to, and which you can see clearly at, for example, paragraph 48 of the appeal skeleton E32 of the Hoplands reopening bundle. We've been there before, I don't ask you to turn it up. But essentially, there's a conflation of the discretion question and the reserve matters stage and the HRA that was considered in respect of that. But the judge didn't consider discretion in respect of the HRA. She only considered discretion in respect of the OPP stage, didn't need to consider discretion in respect of the RM stage. She found that the HRA was entirely complete and satisfactory. But at the OPP stage, where there hadn't been appropriate assessment, that's where she focused. That's obviously 18 months before the HRA, and her finding at paragraph 80 couldn't be any clearer that at OPP stage, inevitably the decision would have been the same. I think in my skeleton I described the claim, at least in those respects, as a masterpiece in technicality, and I don't in any way shrink from that description. As the judge found, in a nutshell, all the relevant issues at OPP stage, in respect of course, the whole of the site, were considered, reflected on. The council had a very detailed report from the predecessors of my client, which set out in very careful terms what the impacts were, what potential impacts could be screened out because of the lie of the land, etc., where mitigation measures would be required, one or two areas, payment in respect of other SPAs that we've not been concerned with, some drainage arrangements, a lighting scheme so as not to shine lights in the direction of Stodmarsh, and the council, having consulted with Natural England, who said we have no issue with the evidence and the conclusions that are reached, in absolutely clear and express terms in the officer report, says taking into account mitigation measures, there will be no adverse impact on integrity of the European sites. Now, they didn't put it in a box where they asked and answered that question under the heading appropriate assessment, and indeed the officer report says there's no need for an appropriate assessment because of what the Court of Appeal has said. But it was always absolutely clear that the self-same fundamental question that would arise as an appropriate assessment was asked and answered, just as I say, it was put in the wrong box. And the judge saw through the challenge and she agreed with those submissions, and frankly, it's perfectly plain from what Justice Lewison said why those grounds of appeal have been rejected, 3 and 4, and it's also perfectly plain why they are dispositive. Anybody in the claimant's position, knowing the history of this litigation, who reads the words, in effect, grounds 3 and 4 rejected, and that is dispositive of the appeal, knows exactly what that means. There is no ambiguity at all, and there was no need for any further detail to be provided. Unless there's anything further.
No, thank you very much, Ms. Benchnick. Yes, Ms. Quickly.
My Lords, my Lady, I'm conscious of the time and I don't have much to add. You'll be grateful to hear. My Lord, I am also in the very happy position of being able to adopt in their entirety the submissions of my learned friend Mr. Furr, insofar as they relate to Chislett and jurisdiction under CPR 52.30. I also gratefully adopt the submissions of Mr. Tabachnik in relation to the jurisdiction under CPR 52.30. My Lords, my Lady, I only have 2 small points to add in relation to particular points on the Chislett refusal of permission to appeal. If I could just ask your Lordships to turn up E41 in the reopening bundle, the Chislett reopening bundle. And this is
back to the red now.
Mine aren't colour coded.
It's getting late, isn't it? It's getting late. So it's back to the red, and it's in the core.
The reopening bundle.
The reopening,
and it's the refusal of permission to appeal at E41, tab 3, back to tab 3.
Yeah.
My Lords, my Lady, just in case it's said against me in reply that the judge's reasons do not deal with all all of grounds 4 and 5, because those aren't in bold, and I know your Lordship's accepted the submissions of Mr. Fur that 4 and 5 effectively deal with grounds 4 and 5. I would just emphasise that, of course, the judge, Lord Justice Lewison, expressly, effectively incorporates the judge's refusal for granting permission to appeal.
Yes.
So he incorporates the judge's written reasons on refusing permission to appeal, particularly in relation to ground 3, as then was. And those are in the core Chislett bundle at E46.
So he's implicitly, he must be referring to the additional grounds.
My Lord, yes, because the judge, when you look back to the judge's reason, Mrs. Justice Lang's reasons for refusing permission to appeal, you'll see at page E46 of the core bundle.
Yeah.
Page, sorry.
E46.
E46 of the core.
Core.
Yeah.
Mrs. Justice Lang deals with what was ground 3 then, in relation to the procedural points in the first part, but then the last paragraph, but even if, contrary to my view, she then deals with the substantive grounds having no merit and therefore permission to appeal ought not to be granted. And she then also cross-references to paragraphs in her judgment where she dealt with those substantive grounds, which included the substantive points being raised in the ground of appeal, particularly relating to, ground of appeal 4, if we look back at...
well, yes.
Yes, grounds of appeal 4 in relation to the habitats.
Yeah, well, obviously it would be an extremely narrow criticism of a judge to make, of a Lord Justice, to make that his reasoning must fail because he hadn't signposted with bold typeface the grounds, having done so for the first 3. But he says in terms the judge's reasoning for refusing PTA on what was then ground 3, and that must subsume 4 and 5, you're submitting.
Well, my Lord, yes, it does, because it doesn't. My only point really is it doesn't just deal with the procedural issue.
And it might be added even if you didn't read paragraph 4 itself of his reasons.
I'm grateful. And then my second and final point was just to emphasise the point in paragraph 21 of my skeleton, which refers back to a paragraph in Clifford, which has already been turned to, and
Paragraph 21 of the skeleton.
21 of my skeleton, page 7.
Okay, just a minute.
In my submission, in Chislett, the applicants don't even get to the first stage in Clifford because I say they fail at the preliminary stage as to whether a question has been raised, has in reality been raised. The mere fact that a question, that a party contends that a dispute gives rise to a question concerning the interpretation of community law does not mean that a court or tribunal is compelled that the question has in fact been raised. And that was the point that was referred to earlier in Clifford at paragraphs 8 to 9. I don't think we need to turn it up now, but it's said in terms in paragraph 9. Yeah. And in particular, the point the reason I refer to that is because this question, which is now of some emphasis in the applicant's skeleton, namely that the contention that because there is an in combination assessment required under the Habitats Directive, that means as a matter of law that the two parties are considered jointly under the EIA regime. That appears to be the question of interpretation which is now being said to have required reasons. My Lords, my Lady, I say that question was not even raised as part of the dispute because it was never pleaded originally in the High Court. And even though
it was refused, wasn't it?
Well, my lady, it wasn't even pleaded in the first place, but then to the extent it was, permission was sought, it's at paragraph 57 of the High Court skeleton, the claimant's High Court skeleton, which is E95 in the core bundle, I think. Paragraph 57 is where the permission was sought in the skeleton to amend the grounds. And it's rather obliquely raised in the first bullet point under paragraph 57.
If it is said that.
If it is said that, yes.
So it's an aspect of insufficient provision of information. That's a slightly different point.
It's not, in my submission, it's not really raised at all. It's just a simple example of why the ES is said to be insufficient. It's not raised as a question of law, squarely or at all, in that paragraph. And you can see that also at page E98, which is paragraph 67, headed HRA aspect. The problem in relation to EIA is starkly illustrated by the approach to information required in relation to HRA. So it's really an illustration, it's meant to be an illustration of the deficiency of the ES, rather than any submission at that stage that as a matter of law, the fact that in combination assessment is required under HRA means that a joint assessment is required under EIA. And of course we know that application to amend the grounds in that way was in any event, as your Ladyship says, refused. And we also know that in the refusal of permission to appeal by Lord Justice Lewison, turning full circle, he refers back and incorporates the Mrs. Justice Lang's refusal of permission to appeal in relation to that aspect. And my lady, those were the only points I had to add, unless there's anything else I can assist you with.
Thank you very much, Ms. Wickley. Yes, Mr. Horn, any reply?
My lords, my lady, if I may begin with the higher test and or the jurisdiction if 5230 is raised a second time on the same grounds.
Yeah.
And what my learned friends all say is that there is no jurisdiction to reconsider where the application is made on the same facts and the same grounds. And my submission in response to that is that it cannot be correct in light of the framing of the rule on its face on the words of 5231. And in any event, it cannot be right because one can think of circumstances, and two were canvassed by the court, in which it would be right to raise the matter on the same facts and the same grounds. First, it may be, for example, that when the 5230 application was considered, it was considered, say along the example given before, not on the correct papers, or not to have looked at the point at all. That's not this case, but it's an example of when the jurisdiction arises. And secondly, it must be right if the point that was raised on the first occasion was not dealt with in such a way as to meet the standard of egregiousness. And it was put that this might be a sort of perversity approach. And indeed, in this particular application, and I'll just give the reference if I may, paragraph 3 on E5 and 6, I think it's in both of the reopening bundles. the case is put in a way that does politely come close to perversity. So it is in fact put to that standard. Second, to deal with the question of what the test would be if there is jurisdiction, which I say there is, and what was proposed was the suggestion of something that is overwhelmingly egregious.
Yeah.
And my submission is that just in plain terms, that does not make sense. Because something that is egregious, as my Lord Justice Lindbaum pointed out, is something that is flagrant. In and of itself, the standard is an overwhelming standard.
All right, so egregious is an overwhelming standard, and inherently overwhelming
Yes, and
standard.
my Lord, you'll recall the discussion that we had, that the language that was being used, very clear, very exceptional, egregious, that is a standard which is high, and high in a way that suggests that one can't posit a higher standard unless one is getting to something that is impossible.
So it's next, I don't want to put words into your mouth, but you really are submitting it's, as it were, next to impossible.
If one is saying overwhelmingly egregious or something more than egregious,
right.
So if the first test is it is egregious,
yeah.
And if the second test that's been posited by my learned friends is something more than egregious, in my submission that can only be that's close to impossible, because egregious is such a high standard.
Yes, but in a sense one's mixing two different concepts linguistically. That's the trouble. Egregious is a kind. It's a word that's perhaps not used very much except by lawyers these days, though one finds it in the dictionary. But it conveys the concept of something that is extremely bad, if you like.
Yes.
Extremely surprising, perhaps.
Yes.
And when the court uses it, it is expressing an extreme.
Yes, correct.
And that's the way you would characterise it. So,
Yes.
But the real effect of your submission, and that's perhaps the point we need to focus on, is that the standard is already so high that for practical purposes it couldn't be any higher.
It couldn't be any higher.
Right.
Precisely so.
Okay.
So, if one paraphrases it, the first LJ looking at it has to decide that it's extremely surprising that permission to appeal was refused for whatever the reason may be. And the second court has to find that it was extremely surprising that the first LJ didn't find it extremely surprising.
Yes, but as I submitted right at the beginning, those two extremes don't square. They don't raise the bar in the way that's suggested by my learned friends, because the standard is of such a level that to square it in that way makes it almost impossible, and that would be the wrong approach.
But that's why I was sort of tentatively moving towards the perversity standard, because once it's been screened by one person, the first LJ, who's looked at it and says it's not egregious, whatever that means, unless it's blindingly obvious that he's gone off the rails or she's gone off the rails somehow, because it would be obvious to anybody that it's egregious, then it seems to me that you can't keep going round in circles. Either it's egregious or it's not. And if an LJ has already decided it's not egregious, then why doesn't it stop there?
But on that analysis, that's the whole point of the way that 5230 is put together in my submission, because that whole line of argument in fact would apply, for example, in circumstances where if there was an initial decision that had been made to say a perversity standard hadn't been reached, say for example on a judicial review where perversity is argued, that's been dismissed, the Court of Appeal says no, your grounds to appeal in relation to the perversity standard simply are not made out, then essentially to square that on the 5230 application would not be right, because it implies a level that goes even beyond egregiousness. And if perversity is in your example, my lady, being used as even more beyond egregiousness, then
Well,
it
no,
becomes a test that's difficult.
I'm not squaring the circle with respect. What I'm saying is the reopening either ignores the fact that it's already been through the filter of 1LJ, or some credence is given to the fact that 1LJ has already looked at it. Now, if the fact that 1LJ has already looked at it is to have any meaning whatsoever, then there must be some means of taking that decision to task, which I think you accept. And therefore that decision has got to be subject to some test, some form of scrutiny. And all I'm postulating is that because it's a discretionary decision, and because the test is one of egregiousness, so that the test that LJ has to apply is one of egregiousness, you could either say, well, the LJ didn't actually apply that test at all, in which case his or her decision just doesn't apply the right legal test. Or if they did apply that test, it can't simply be said, well, they got it wrong because it's egregious. It's got to be a perverse decision. It's got to be outside the bounds of that which an LJ acting as that kind of filter could reach, surely.
My lady, no, because when one is applying 5230 in any circumstance, and as your ladyship pointed out, in this case, the page isn't blank. The application is to the decision that was made on the first application. So it's being applied to that decision. The standard is one of egregiousness. So it cannot be, and this is precisely the point that's being made to counter the suggestion that this is some kind of appeal. It isn't an appeal because the standard is so high.
I think you can tell our concern is simply based on the fact that this will be the first case that addresses this point, because you've helpfully drawn our attention to Saliba. And what we would be anxious to do would be not to give the impression that 5230 was forever open until you found an LJ that agreed. And if the test is not the same, and if you're not acknowledging the fact that an LJ has looked at it and have reconsidered it, but no for these reasons, then that is the clear and obvious danger.
Mm. My lord, first I have no doubt that the judgment will make clear that this is not something which is to be done lightly or to be done on every occasion, that there's a disagreement with the first 5230 application outcome. But with respect, that reasoning was precisely the reasoning that was applied in order to give rise to 5230. Because as we canvassed...
That was the one-off, because before Taylor and Lawrence, you couldn't do it at all.
Yes.
And somebody said, well, hang on a minute, that can't be right.
Yes.
But Taylor and Lawrence doesn't deal with having another go.
No.
That reconsideration is refused once, but then is allowed again. I mean, as you will know, it's a commonly held view that that's the trouble with judicial review.
My lord, just focusing on the way that this rule was put together, that 5230 was formulated. It was formulated in my submission to deal expressly with this concern about essentially gung-hoism around the making of an application. And in my submission, if this court determines there is jurisdiction to make this application again in relation to a final decision which deals with a 5230 application, the way in which this rule is formulated and the test this rule applies is sufficient bulwark against a tsunami of second applications, because the test is applied so highly to begin with.
Yeah. Let's just take your thought and slightly swivel in our focus. Not this case.
Yes.
I preface what I'm going to say. We start, say, with the principle of finality.
Yes.
And we all acknowledge that there is value and importance in the principle of finality in planning as in other areas of the law. Finality is a good thing in principle, but not to the exclusion of justice,
Correct.
which is where we now come in. The rules permit, it might be said, an opportunity and a realistic and fair opportunity for a litigant aggrieved by a decision to refuse permission to appeal from an unwelcome judgment in the court below, to check that something hasn't gone seriously wrong in the handling of the application for permission to appeal. It's a safety mechanism to ensure that justice hasn't been denied by what is in effect something going, let's detach ourselves from the language of egregious, something going very seriously wrong,
Yes.
very seriously wrong
Yes.
in the disposal of the application for permission to appeal. That's the utility of the 5230 jurisdiction.
Yes.
Can we all agree on that?
Yes, we can.
Right, so it's there for that purpose, essentially.
Yes.
When you put yourself in the context of the applicant still not accepting the outcome, unwelcome as it is, then something is happening that is not, it's not precluded in terms by the rules, but it's not contemplated by the rules. Let me finish if I may. In circumstances where there hasn't been something new, at least, which changes the picture in a material way, and that perhaps does logically point us in the distinction between new facts, something emerging about the base decision that wasn't known before, on the one hand, and the situation where the applicant is simply having one go after another. And do you accept that distinction in principle?
My lord, that's where we part company. And I think your lordship's own analysis shows why we must part company.
Does it?
Because if 5230 is the safety valve
Yeah.
that your lordship posits,
Yeah.
then it must be right that that safety valve can be applied again where it is valid or justified to do so.
Well, that's really where I came in with my analysis.
Yes.
See, that doesn't address my analysis. That merely prompts the need for it.
But in effect it does, because if the safety valve hasn't operated the first time, because to the standard that the rule itself understands or the rule itself sets,
But who says?
then the safety valve should be able to operate again.
Who says that it hasn't worked?
But that's the point of making
Well,
a second application.
Well, that's effectively the litigant saying, isn't it? The litigant saying ad infinitum, I'm not happy, I want to have another go.
It's a safety valve for the safety valve.
But in positing it in that way, your lordship unfairly characterises the second application as just on the basis of unhappiness. Whereas, in fact, where this court started this morning is that even the first application, any application under 5230 might well just be unhappiness with the decision.
To be fair, Ms. Dayon, and realistic, let's try to be both fair and realistic, there comes a point in the whole process at which the outcome has to be litigants, as my lord has pointed out earlier on, and I won't put it in any extreme terms at all, but litigants are often unhappy with the outcome of the proceedings in which they've been involved.
Yes.
It's quite a normal phenomenon.
Yes.
Judges get used to it.
Yes.
We're talking about going beyond that degree of finality provided for in the rules and contemplating a further stage at which potentially the decision is undone.
Yes.
And I mean, do you accept in principle there has to be a point at which disappointment has to be borne?
My Lord, I don't accept the way that your Lordship formulates it, because this is about being disappointed. And the point is perhaps made out by the fact that this is one of only a handful of times in the whole existence of this jurisdiction that it has ever been sought to be exercised twice. This goes beyond the normal disappointment of a litigant with an...
Well, who says? Because there's an application that's self-serving.
Exactly.
Isn't it?
It's
entirely self-serving.
It's not self-serving for this reason. So first of all, yes, who says it? Obviously the applicant is going to have to say that in the first instance. But here we are in a hearing on a point because this court saw something more than just a disappointed applicant saying something again.
This court, you mean the court that ordered the matter into open court?
Yes.
No, this court saw the need for the matter to be, this whole question of a secondary Taylor and Lawrence style application being made to be properly addressed on submissions in court. There was no, as it were, preconceived view about outcomes.
No.
There was, however, the perception that this was a matter that needed to be properly addressed on oral submissions.
But with respect, had the second application been such that there was nothing to it, that it was simply a litigant who was endlessly upset and would not be placated, if there was nothing to it, if there was no CJEU point that detained us for an hour earlier on about whether that makes a difference or not in these circumstances, if there was nothing of that in this application, then my submission is we would not be here.
Well, you have read the reasons I gave for ordering it into court.
Correct, and that's why the focus of all my submissions before your Lordship and Ladyship today was to address that point, was to address why this is a different type of case, why this does make a difference, and why a second application, the second exercise of the safety valve, is right in these circumstances.
Well, we've heard that submission.
I'm grateful. I don't think I can take this matter much further. So if I can move on then.
I very much doubt it.
The second, that I can move on.
No, I think you've made very full submissions in answer to our questions, and we're grateful for those submissions.
I'm grateful, my Lord. I can move on, and the next element that I will address is the reasons question. And I need to deal briefly with the cases to which my learned friend Mr. Ford took the court. Mothers of Srebrenica, and that reasons can be implicit. And on this point, I say two things. First, first, we need to go back to Rezabek in order to see what that case said. So if I can ask the court, please, to turn up Rezabek again which is tab 58. And the paragraph, I think, is paragraph 62. Although when my laptop deigns to wake up, I can confirm that.
The last few lines of paragraph 62.
So it's, as I recall it, it's all of paragraph 62, because that references the correct standard to be applied in these particular circumstances, where one is dealing with a question of reference to the CJEU. And what is said there is that...
Did we not look at that this morning?
We did, but I don't think the import of it was properly understood in light of what was said later about the other cases, and why it was said by my learned friend that they had the effect that she suggested. Because it's absolutely clear in this paragraph what the standard is to be applied in these circumstances.
Doesn't say anything about express reasons.
And
It just says there's an obligation to give reasons for their refusal, to indicate the reasons why they found that the question is irrelevant,
yes,
or that the European Union case law has already been interpreted,
Yes.
or that the correct application. So
yes,
there has to be sufficient reasoning, and all that Ms Tafel is taking us to is to say that it can be implicit rather than explicit. And if it's blindingly obvious what the reason is, then you don't need to spell it out.
So this is why this is the first of two submissions. And the bit that I rely on, and this also is in answer to something, my lady, that you put to me earlier, it's clear that what this case finds is that the court is obliged to give reasons for their refusal in light of the exceptions provided for in the case law of the Court of Justice.
Yeah.
And the submission that flows from that is this. The reason cannot simply be a repetition of the criterion. So it's not sufficient to comply with this, to say the reason that I refuse to refer is because the matter's irrelevant. Because that's the criterion. The criterion is, for the exercise of discretion, is it irrelevant? Is the case law that deals with the point, or is it act clair? And what this says in terms is that you're obliged to give reasons for your refusal in light of the exceptions provided by the case law. So what will be required in accordance with the Silford or Chilford case is to indicate the reasons why they have found that the question is irrelevant.
We dealt with that this morning too, and we asked you what the judge should have said.
We did, and
You didn't
this is
answer.
Never quite got an answer to
well.
that
This is
question.
my answer. What has to be said is the reason why it is said to be irrelevant. It's not sufficient simply to say it is irrelevant.
So, if the judge says it is irrelevant because the question is purely academic, since the judge decided dispositively of the case on a completely different ground, which this doesn't touch, that would be sufficient.
My lady, anything that gives the reason for why the question is irrelevant, formulated in order so that the reader can understand that that is the reason for it being irrelevant.
Right. Now, are you saying that that has to be spelt out expressly, or is it enough, in accordance with the other European case law, that it be obvious?
It has to be explicit, because the other cases do not deal with this specific circumstance. There is, to adopt my Lord Justice Coulson's words, perhaps rashly, there is a magic about this particular circumstance.
Well, I've been waiting to get to that. Because
Yes.
that's what I thought.
Yes.
Speaking for myself, I don't agree, but that has to be the case. There has to be magic
Something
about the reference
special.
to questions, otherwise we're nowhere near
And
5230. But anyway, that's very clear. That's ultimately the submission. In these circumstances,
in these circumstances,
the reasons have to be spelt out, even if they're implicit. They would otherwise be implicit.
it would otherwise be implicit.
So even though in the Hungarian case, the CJEU says that the court could have explained more explicitly why it refused to make a preliminary reference to the CJEU, so that's a refusal to make a reference, but an implicit reasoning could be considered sufficient. That doesn't apply if it's not a preliminary reference, but some other kind of reference.
My lady,
Bottom of 1434. Top of 1435. That's all about making references to the CJEU, as I understand it. And what's said there is an implicit reason for refusing to make a preliminary reference to the CJEU is fine. But you're now telling us there's a magic about refusing to make a reference to the CJEU, and you need to spell out the reasons for your reasons.
I'm relying on the case, the key case that deals with the question or the point on which I rely, which is Rezabek. And Rezabek, in my submission, makes it plain that what has to be, the task that falls to the court is one where the reason has to be given as to why the discretion has been exercised, or the element of the discretion has been relied on in that way. The reasons don't have to be detailed. The reasons don't have to be anything other than a clear reason as to why that outcome has been reached. And in my submission, the case that's entirely on point in these circumstances is Rezebek and not the other cases.
Well, why is the Hungarian case not in point? Because I don't understand it at the moment. If the Hungarian case is all about preliminary references to the CJEU, what's the distinction that you're seeking to draw between that case and Rezebek?
My lady, in my submission, where it's absolutely clear, where the court has given or made it absolutely plain in the way that it does in Rezebek, and I note, although I'm just checking that I'm right about this, that Rezebek was not something that was discussed in the Hungarian case. My submission is, it wasn't. My submission is
The Hungarian case is wrong, or it's per incuriam.
that that's the correct approach.
So on that basis, there's two conflicting European cases.
But in any event, even if the reasons can be implicit, they must be such as to be understood. And it's not, in my submission, correct to infer an implicit reason simply from the stating of the criterion. So to make that good, if the Lord Justice can exercise a discretion on one of 4 grounds, one cannot imply the Lord Justice's reasoning if all that is said is, I exercise my discretion on this ground. The stating of the criterion is not sufficient for explicit or indeed implicit reasons to be found. It is brought to my attention that Rezebek is dealt with, and I knew as I said it I needed to be absolutely sure, and I wasn't.
Do you want to pause for a second?
So,
Reflect.
well, I think the submission that I've just made makes the point, which is even if implicit reasons are capable of being given, then simply restating the criterion is not sufficient to give rise to that implication being drawn.
Right. Understood. Thank you.
And what my learned friend submitted is that the reasoning of my Lord or Justice Lewison was necessarily implicit. And in my submission, on the basis of what is actually said in the decisions, that is not correct in this case. And it must be recalled that the question of the reference to the Court of Justice of the European Union was raised as clearly as possible, and much has been said about whether there was clarity in the grounds, but perhaps it is the plainest of grounds that the question of reference to the Court of Justice of the European Union and what that reference should be was raised absolutely clearly, first on the application for permission to appeal, and then in even clearer terms, secondly, on the first 5230 application. And in those circumstances, where in fact 5230 was put on the basis that this question required to be dealt with, and to be dealt with to the Rezebek standard, in my submission, again, it's not right for a necessary implication to be good enough. in these circumstances.
Sorry, so you're saying that if there is a necessary implication, that isn't good enough?
I'm saying that in these circumstances, for my own friends to assert that there is a necessary implication doesn't reach the standard.
Well,
Sorry.
Forgive me. I think it's this, isn't it? There are two submissions. One is it is not in fact you submit necessarily implicit in this case.
Correct.
Submission 1 and
Yes.
submission 2. Even if it were necessarily implicit, its being necessarily implicit wouldn't be enough. I think you've made both submissions. In other words, just to get it absolutely crisp and clear, it needs to be spelt out, and it wasn't, is your submission.
And I think, yes, because of the specific nature of this case.
Yes.
And that
Yes.
goes to why this case is different from
It's
other
predicated,
cases.
forgive me, I'm so sorry,
Yes.
what I've just said to you is predicated on that
Yes.
concept.
Yes, because
In the circumstances of this case, it needed to be spelt out and it wasn't, is the submission. Is that right?
my lord, I think the clearer and safer submission, and I think it's the one that I'll make,
Right.
is the first submission, which
Right.
is that it is not necessarily implicit in this case.
Sorry, say again. It's not.
It's not implicit. It's not necessarily implicit in Lord Justice Lewison's reasoning. I don't think I need to or should go further than that.
Right. Well, that's very clear. Yes?
Finally, before I get into the specific cases, and I don't have much to say on them, finally, just to be absolutely clear on the nature of the discretion. Because where a reference or a request for a reference is made, the principle of effectiveness and the basis on which the Silfit jurisdiction or the Silfit judgment was put forward arises. Although there is a discretion not to refer, that discretion is in my submission, not the normal wide discretion that is given in common circumstances, but is a discretion that is exercisable in light of the Silfit grounds, if I can put it like that. And that in my submission is important and differentiates this case from other cases in which a general discretion is exercisable.
But not any other case in which somebody wants to run a Euro point.
No.
It'll cover every case in which somebody wanted the court to refer a case to the European Court.
Yes, the standard must be the same across all of those cases,
Yeah.
yes. I know, yes. Before I turn to the two specific grounds, or the two specific cases, can I just draw the court's attention in my skeleton argument to page 3 on page 23.
Is this something we can gain by reading the skeleton
Yes.
argument?
And
So you're
it's
drawing our attention to paragraph 83.
paragraph 83 on page 23, and it's the reference there to Frankovich and the court's independent duty to see EU law observed.
Right, well, I think we're
Is that a
familiar
reply point?
with that.
Paragraph, yes, it is, because it leads directly to what I'm about to say on Chislet.
Right.
So dealing then with Chislet.
And now we're at 25 past 4.
Yes.
How long have you got in mind to
My lord, I have to deal with
address us with?
1 point on Chislet and 2 points on Hoplands, the one being the prejudice point, and then I'm done.
Can you do that in 5 minutes?
I can do that in 10 minutes.
Right, you have 10 minutes.
I'm very grateful. So Chislet. The way in which the point was described in response to my submissions in my submission didn't fully grasp what is being said in the Chislett case. And again, if the court refers to paragraph 89 of my skeleton argument, there it's made clear that the nub of the Chislett error or the Chislett issue is that there is no domestic jurisprudence dealing with this particular question, i.e. adjoining or adjacent developments applied for at the same time, close to the same site, which require EIA and HRA in combination assessments. So this distinguishes it from circumstances where there might be an EIA and an HRA happening together.
The problem with that is that the case below was not run on the basis that even if they were adjoining but separate sites, there should have been a joint assessment.
And in my submission, that's not right for this reason, because the case below explicitly relied on Abraham and Ecologistas, and this is where Frankovich comes in, as being the correct European Union approach, and that's in paragraph 90 of the skeleton, and there being a genuine EU point on how Abraham and Ecologistas apply in these particular circumstances.
Well, yes, but it was never pleaded and never put as a ground. The ground that was pleaded was the council got it wrong in not treating these as one project. And they should have looked at it as being one project, and they never did. And the judge found against it on both of those points. But there was never, ever an alternative case that was put in Chislett on the basis, if we're wrong about that, and actually as a matter of domestic law, they are separate projects, because of their close geographical proximity, then we've still got an Ecologistas point, which requires, as a matter of European law, for you to ignore the fact that they're domestically treated as entirely separate grounds. It's just not there. I've been through it really thoroughly. And that was not the case below.
My lady, in my submission, in light of Frankovich, the case being put as it was in the application for permission to appeal, drawing out of what had been said below, and not to my ladyship's standard of being absolutely plain, but what
not
was
any
civil
standard.
procedure rules standard of being plain.
What was said below on grounds 1 and 3, and I'm mindful that I only have 10 minutes. Grounds 1 and 3 in Chislett did, in my submission, interact to give rise to this point. And Abraham and Ecologistas were explicitly referred to in the grounds below.
You say that the point was necessarily implicit. Yeah. Well, I mean, that's a serious question, actually.
My lord, in light of the way in which the case came before the court below and how Abraham and Ecologistas were discussed in the case, it is my submission that the point arose. So it wasn't an implicit point, it was a point that was aired.
The point arose explicitly.
The point arose. It's a genuine point of EU law.
Sorry, I'm so sorry, forgive me. I know you're short of time, but we need to get your submission absolutely clear to do justice to it. Yes. The point arose explicitly, or the point arose implicitly?
The point flowing from Abraham and Ecologistas in my submission arose explicitly.
Explicitly, and you'll give us the reference. We don't need to go there, but just if you give us the reference. Perhaps somebody supporting you can do that for us before you finish.
Thank you. And the submission that flows from that is that paragraph, and this is paragraph 95 of the skeleton.
Your skeleton?
Yes, and the reopening application. No, forgive me, it's paragraph 95 of the reopening application. Makes it absolutely plain why there is a genuine point of EU law here. And when the question is raised in this way, it has to be addressed clearly. So it's page E52, paragraph 95 is the genuine point of EU law. Then while I know the reference will be coming. I move on to Hoplands just to say two things. First, it was said that paragraph 12 about how discretion was unlawfully exercised was put on a false premise because the partial HRA was not the basis on which discretion was exercised. It was exercised in light of what would have been the full HRA on outline planning permission. And in my submission, first, that's not right, but secondly, even if one is looking at just the evidence that was before the High Court on what was carried out in relation to the outline planning permission, that was the report to inform the HRA, which was not itself an HRA, it must always be recalled, and did not deal with in-combination impacts. So the partial HRA point arises on both instances.
In-combination impacts were dealt with in the environmental statement.
Yes, but the environmental statement is not, and this is...
And before you say the environmental statement didn't take into account in combination with the HRA, that point was one on which the judge refused permission to run a point. So you get going round in circles here.
I'm afraid this is also all new to me as well. I object to viewpoints being taken.
Well, I have been troubled about the extent to which this is a reply.
But where is this point in your skeleton argument? Can you take us to that, Mr. Allen?
Well, first of all, in terms of reply...
Mr. Allen, would you attend to my question, please?
Yes.
Where is it in your skeleton argument at this point?
Turn up my skeleton, I would be able to answer, my lord.
Is it 95?
Ah, sorry. My lord, yes, it's 95, and I know there was another reference as well that my lord Junior referred to.
Right. Well, now, my lord's question. I mean, how is this actually a reply point? Of course, we take into account your written submissions.
Yes.
In your skeleton argument. But how is this, as my lord asks, a point properly taken in reply? To which submission and whose is this a reply submission?
Yes. So it's a reply to the submission that paragraph 12, i.e. the question about whether discretion was exercised unlawfully, i.e. the mixed question of fact and law, the lawful part, was a false premise because partial HRA was not the issue.
This is a point under the heading Chislett in your skeleton argument.
I apologise.
Or is it? I think, well, perhaps it is, perhaps it isn't, I don't know. I think it is.
Yes, it is. My apologies.
Well, I simply point that out to you so that you don't give us an answer that isn't quite right.
Yes, I know the references were provided to me. We just managed to...
All right, well, take your time. We're not going to rush you, but we do want, please,
yes.
a response to our questions.
Yes. Yes, so it flows in my skeleton argument from paragraph 72. understand from what was said in the description in relation to Hoplands, my hand on it.
Is it paragraph 73?
Earlier in paragraph 21, and then also in paragraph 73 at the end, I think.
Right, well, bearing in mind not merely the time, but also the question that we've asked you, how
Yes.
and to whom is this a submission, or in respect of whose submission is this a submission in reply?
Yes.
Would it be satisfactory, do you think, for us to note those references and read carefully what you say in your skeleton argument?
Yes, and it's in reply to the submission by my learned friend Mr. Four that paragraph 12, the question about discretion, was put on a false premise.
Are the submissions made in your skeleton argument adequate from your point of view or not?
My lord, yes, they're adequate.
In which case we undertake to read them.
Yes, thank you. Then moving on to the prejudice point, which is one not yet addressed. The witness statement that has been provided on behalf of Redrow makes it clear that what has happened on the site is at the north of the site, which is not the area with which there's particular difficulty. It's not the part of the site that's close to Stodmarsh. But in any event, the point about prejudice can be dealt with in this way. If permission to appeal were granted as a result of this reopening, then plainly the points on prejudice would be taken into account and would go to relief. So there is a safeguard in relation to prejudice, and such prejudice as might arise does not, in my submission, overcome the errors that have been set out and in my submission made good in the application. Our application, the applicant's application. What was also said was that the applicant essentially did not act quickly enough, and in my submission that's not right. The application was lodged on the 27th of March, and one can see that at the end of tab 1, i.e. as soon as practicable after Lord Justice Lewison's reasons had been digested. And indeed, the interested parties were told that the application was to be made. And that is itself also stated in the application. So it's simply not right that there was any delay. If I can have one final minute just to say this. It is undoubtedly a difficult task to come before the Court of Appeal to say that one of its fellow judges has slipped into error, and that's why I began by saying that everything that was said in this application was made with the utmost diffidence and recognition of the experience and expertise of Lord Justice Lewison.
Well, speaking for myself, I don't think you've trespassed beyond that at all.
Very grateful. But it is right, of course, that the 5230 jurisdiction means that judges can err, even when it's envisaged that the error is a fundamental error of law. And Goring, paragraph 60 to 69, recognise that the extent of the error can be a fundamental legal error, such as to trigger 5230.
Mr. Hon, if it's reassuring, I wholeheartedly endorse what my Lord has just said. which is of course only consistent with the oath that we take as judges.
Absolutely. Yeah. My lord, my lords, my lady, unless I can assist further. Ah,
There's references to the Colchester's name there. Chislet.
yes, the Chislet references.
Do you want just to spell them out for us? Thank you.
Yes. So the skeleton in the High Court, it's E99 para 71.
Yeah.
E99 para 60, if I'm reading that correctly.
Yes,
It's para 60. There's E50 para 34.
Right.
In the Statement of Facts and Grounds, it's E18 paras 70 to 71 and 75.
Supplementary skeleton.
That's the that's the supplementary skeleton.
No, that was the. Sorry.
It's too late in the day for me to understand these. So the supplementary skeleton, I think, is E50, paragraph 34. I think that must be right.
Sorry, that was the skeleton argument. You gave us 34.
Yes,
yeah.
E50 paragraphs, E150.
So we've got
E150.
skeleton argument in the order you gave us.
60, 71.
Yeah, 71, 60, 34, Statement of Facts and Grounds, 70 and 71 and 75.
Yes, my apologies. Paragraph 34 is on E150. That's the supplementary skeleton. It's not the... So
Right.
it's not on page 99, it's on page 150.
Right.
My lords, my lady, with that diversion, unless there's anything I can assist further, those are my submissions.
Thank you very much. Well, thank you all very much for very clear submissions and all the care that's been expended on both the oral argument and skeleton arguments as well. We're very grateful to you all. Thank you. We shall reserve our judgment, which will be handed down as soon as possible under the normal arrangements. When I say the normal arrangements, I have to be careful because normal arrangements may conceivably change, but under the arrangements that will be normal at the time when judgment is handed down, I think is the sensible thing to say. You'll have the opportunity anyway to correct any typographical or minor factual errors in the normal way, and there should not be any need for the attendance of counsel at hand down in any event. Thank you all very much.
All right.